Welcome to Then and Now, a podcast by the UCLA Luskin Center for History and Policy. We study change in order to make change, linking knowledge of the past to the quest for a better future. Every other week, we examine the most pressing issues of the day through a historical lens, helping us understand what happened then and what that means for us now.
Hello, I'm David Myers, host of Then and Now. We are living in one of the most consequential epochs in the history of the United States. The Trump administration's desire to redefine the rules of the political game and the nature of government authority rests on a vast expansion of what is called the Unitary executive theory, the belief in the singular and unrestrained power of the president to do as he pleases with the executive branch. So expansive is the current theory of executive power that it threatens to recalibrate altogether the balance of power among the three branches of government in the United States. How has the idea of the unitary executive evolved from the time of the Founding Fathers? On what legal principles does it rest? And what legal principles can restrain it? And what can the courts do about it? To answer these questions, we are joined today by John Mikhail, the Carroll Professor of Jurisprudence at the Georgetown University Law Center. John is the author of many articles in a diverse array of fields, including constitutional law, moral psychology, moral and legal theory, cognitive science, legal history, and human rights. And he is the author of the 2011 book, Elements of Moral Cognition, Rawls' Linguistic Analogy, and the Cognitive Science of Moral and Legal Judgment. Welcome to Then and Now, John.
Thank you, David. It's a pleasure to be here.
So can you tell us what actually the unitary executive theory is?
Sure. It's a theory about the nature and scope of presidential power. And it principally stems from a clause in the Constitution called the vesting clause, which is in Article 2 of the Constitution, and which says very simply that the executive power shall be vested in a president of the United States of America. And most of the debate around the unitary executive theory is what the correct meaning of that clause is, what its origin is, what the founders intended it to accomplish, and so forth. But that's really the starting point.
And what was the nature of the debate back in the late 18th century amongst the founding fathers? Did they make explicit reference to the idea of a unitary executive, or is that a term that was introduced later? And what were they debating? I mean, this is about a political process that is going to separate the new United States from the monarchy in Britain. So clearly there was a lot of thinking about what kind of executive position should be at the top of the political pyramid in the United States.
That's right. And it was a topic of extended debate in the Constitutional Convention. So the founders went back and forth on different ideas about how to design the executive department of government. I guess as a bit of background, the idea of the unitary executive can be found in the British Constitution. So it was an idea that the founders were familiar with. And in a commentator like William Blackstone, for example, who was sort of the principal expositor of British law, you find statements describing the British king as, in effect, a unitary executive, someone in whom the executive power of the nation is vested. And the framers were familiar with that model, and they had particular views about how that model had unfolded in British history, in recent British history. And I guess a short version would be that they typically, most of them, I think, held the view that the British system of government, which was thought to be a nicely balanced system of government, had been perverted, had been distorted over time, and come under too much parliamentary control. They actually thought, and this is perhaps surprising to some listeners, they thought that the British king had lost or relinquished many of his powers. And in some sense, what they were trying to do with the American Constitution was to reassert the independence and unitariness, if you will, of executive power.
I just have to interrupt and say that is a counterintuitive proposition.
It's a counterintuitive proposition because we think of the American Revolution as a revolution against royal authority, against the king. That's the way the Declaration of Independence reads and so forth. And of course, to a large extent, that's true. A bit of background on that point is that the colonists, when they revolted in 1776, the principal, architects of that revolution, took it for granted that Parliament had no control over them. They had their own independent legislatures at the colony level, and Parliament, they thought, was wrongly exercising control over them. But what many of them thought was that their savior or their salvation under the British system should have been the king. What they called for was the king to rein in Parliament, the king to exercise his veto power, for example, which he had, and to reassert the proper kind of control that he was given under the British Constitution for the colonies. So they actually, this is the theme of books by, for example, there's a scholar, a professor at Harvard named Eric Nelson, who wrote a book called The Royalist Revolution. And his counterintuitive thesis was that the framers, the principal framers of the Constitution, were actually trying to reaffirm a certain model of executive power that was attractive to them and that they thought had come under a whole series of, developments in Britain: corruption, ministerial control of government, parliamentary control, and so forth. So it is counterintuitive, but it is important to understand, as we talk about the unitary executive today, that there was certainly a faction at the Constitutional Convention that was very interested in establishing a strong, independent executive with executive powers, and that would be a unitary executive. That is to say, the powers would be vested in a single person, rather than other models of executive power that they were considering at a time, basically like a ministerial model, where a council or a group of ministers or a multi-member body might have exercised executive power.
So just so I understand correctly, would it be fair to say that the Founding Fathers were more concerned about an excess of power in the legislative branch than in the executive? And were there any Founding Fathers who sort of could imagine an aggregation of power in the executive that would be dangerous?
Yeah, it's a great question. I think the answer to the first question is yes. I think given their experiences, they were more concerned by and large with an excess of legislative power than an excess of executive power, although they were concerned about both. They certainly understood that concentration of power in any one person or department was dangerous. And so clearly they designed a constitution with checks and balances in that way that we're all familiar with. But going to your second question, there were certainly members of that Constitutional Convention who objected immediately to the idea of a unitary executive. So in the very early days of the convention, one member who I'm particularly interested in and have written quite a lot about, his name was James Wilson. He was a delegate from Pennsylvania, very important founder, although underappreciated today by many. And he later became a justice of the Supreme Court. He stood up in, the early days of the convention and said, here's what I think the executive power of the government should look like. And his first and principal proposal was that it should be a unitary executive, vested in a single person. And the reaction was swift and critical on the part of other delegates. And what they said was a single executive or a unitary executive would be the fetus of monarchy. That's the phrase that one of the delegates, Edmund Randolph from Virginia, used. And later in the ratifying conventions, this idea was repeated. So Patrick Henry, for example, in the Virginia ratifying convention, described the new American presidency as something that was, he said, squinting toward monarchy. So many of the anti-federalists and also many of the framers of the Constitution, so people who supported the Constitution and helped design it, were very worried about too much power in the executive. And, we can talk more about how they tried to check that power, but it did stem initially even from the decision to concentrate the power in one person rather than in, a broader group of people, a council or a group of ministers or something of that sort.
So the founders were tacking in some sense between two extremes, between the extreme of an excess of power residing in the legislature and their fears that an executive might, over the course of time, accrue too much power. Um, how long did that concern continue? Did it continue through the term of George Washington as president? When you actually now operationalize this principle, did that concern persist about too much power in the presidency, or did George Washington lay to rest any concerns that the anti-monarchists in particular might have had?
Well, that's another great question. Washington played a signal, important, paramount role in the way the presidency unfolded. And it's important to realize that when the Constitution was being drafted, it was more or less taken for granted by the framers in Philadelphia that Washington would be the first president. And scholars have kind of thought that this is actually quite important. So as they're designing the presidency and debating its various features, literally in the room is George Washington. And moreover, a large number of the delegates to the Constitutional Convention had served in the Continental Army in one form or another under Washington's command. These were men who had a lot of trust in Washington, expected him to be the first president, and had experienced his judgment and his use of power as a commander-in-chief in that case, but also, someone who's essentially running a large part of what the American government was doing, running the war effort. So that colored the way they thought about the presidency. And some later commentators have thought perhaps it may have led the framers to be somewhat complacent about the powers that they were giving to the new president. Remember, at this point in time, there was no term limit written into the Constitution about how long a president could serve. The president was made re-eligible for election. It was a decision by Washington in his first presidency to limit himself to 2 terms. It wasn't entirely clear how long Washington would serve or another president would serve. And, so the original Constitution did design a presidency that could persist for a very long time. And Washington, there were some critics of things that Washington did. It's certainly the case that he wasn't beyond reproach. So as the presidency unfolds, the first and second Washington administrations, although I would say he had a lot of support in the public, and he was elected by overwhelming margins. There were critics in Congress. There were anti-federalist and later Jeffersonian politicians who thought he overstepped in various ways. The critical moment came with the Adams presidency, because that's when we had the real flowering of hardened political parties, as it were, and a lot of attacks on things that Adams was doing. And maybe Adams' personality and temperament, and he was easier to depict as an unattractive executive, squinting toward monarchy, if you will, than Washington was.
Mm-hmm. And as we move forward into the 19th century, who were considered abusers of the limitations set on executive power? Were there examples of people who seemed to have a very robust sense of the unitary executive before the more contemporary discourse about that phenomenon? What does the history of the 19th century look like in terms of the evolution of unitary executive power?
So I think the 19th century is generally thought of as a period with weak presidents, relatively weak presidents, with a few exceptions. So the big exceptions would be people like Thomas Jefferson, Andrew Jackson, and Abraham Lincoln. So those 3 in particular stand out historically as strong, relatively strong presidents, certainly in comparison with their peers, others who had held the office, in doing the kinds of things that we now associate with the unitary executive theory. One area in which this manifests itself is in, and this is something we could continue to talk about because it's relevant today with the Trump administration, is the so-called removal power. So one of the notable features of the Constitution is that the power to appoint officers of the government is laid out in some detail, how it works. We have nominations by the president, 2/3 of the Senate confirms. And that's for so-called principal officers of the government. And then there's a clause in the Constitution for how inferior officers of the government are appointed, and Congress essentially has some choice in the matter. It can delegate an appointment authority. What's not addressed in the Constitution is who gets to remove government officials, who gets to fire them. And that was a very important question at the founding and throughout this period of the 19th century. Let me just sketch a couple landmarks for you. Just going back to the 18th century, the really important initial development of this topic was in 1789 in the first Congress, when Congress drafted the statutes that created the departments, the original departments of the federal government, which were War, Foreign Affairs, which later became the State Department, and the Treasury Department. So Thomas Jefferson is the first Secretary of Foreign Affairs, later the first Secretary of State. Alexander Hamilton is the first Secretary of the Treasury Department. And a man named Henry Knox was the first Secretary of War. And what Congress had to decide when it drafted those statutes, or an issue that arose, was, well, who's going to get to fire the officials whose positions we're creating and who the president will get to appoint? And to cut a long story short, there was a big debate in Congress that later commentators, including the Supreme Court, have dubbed the decision of 1789. And the decision of 1789, as it's come to be interpreted, was to give the removal power to the president. Or let me put that differently. It was an understanding that Congress, in debating this issue, had decided that the Constitution vested the removal power in the president. That is the holding, or one of the holdings, of a case that was decided in 1926 called Myers against the United States. Very important case for laying the foundation of the modern theory of the unitary executive. And that is controversial, and I don't want to go further onto that, the different sides of that controversy right now. But going back to your question, people like Jefferson, Jackson, and Lincoln made strong use of the removal power. They did that in a way that exemplified the strong unitary executive, and generally tried to control the exercise of statutory discretion in the executive branch through the use of the removal power, either explicitly or as a threat, in ways that we can now see led to the development of this theory. Whereas other presidents maybe tended to use that a little bit less, or the Congress tended to have a little bit more control over how officials were appointed and removed.
Mm-hmm. So the alternative proposition would be to the holding in Myers that it would not be the president, but Congress that would have the power to remove officials in the executive branch?
Yes. So there were actually four theories, and it's worth just briefly describing them for you. One was what's called the impeachment theory, which says actually the premise that the Constitution doesn't address this question is false, because there's a whole process for the impeachment and removal of officials laid out in the Constitution, and that's the way that's the only way government officials can be removed. And most members of that first Congress thought that was too extreme, that, an official can deserve to be removed and should be removed for conduct that falls well short of impeachable conduct, high crimes and misdemeanors, and so forth. The second theory was a theory that held that because the Senate played a role in confirming appointments, that it should have a role in the removal. So the idea was that the power to appoint sort of implies a power to remove. And so maybe the president and the Senate together would have that power. That didn't command a lot of support either. The third alternative did command a lot of support, and that goes to your question. It was that Congress, through the necessary and proper clause, has the power to, by statute, declare the circumstances under which government officials should be removed. And then the fourth theory was the presidential theory, which says that the Constitution gives the power in Article 2 to the president. So the two big rival theories were, on the one hand, The president has that power constitutionally, and that is the, if you will, the forerunner of the modern unitary executive theory, which still we are, living with and dominates the jurisprudence today. But the other big alternative theory, and you do see this in recent case law, members of the court today, like Justice Kagan and others, appealing to this theory, was that Congress, through its necessary and proper clause power, had the power to lay out the terms under which officers could be removed. And to make that concrete, what that typically meant was, for example, Congress could say that we're creating an office, we're creating the office of Secretary of State or the head of the FBI or what have you. And since we're creating the office, we can also create the terms of the office, how long the appointment shall last for. And most importantly, we can put into the law that there are so-called for-cause removal provisions that the president must comply with if and when he decides to remove an official. So president can't just at will remove the officer, but must do so for cause, for good reasons.
Yeah.
That's the sort of boundaries of the debate today, more or less.
Yeah, I'm just thinking of a comparative example. In Israel, there is what's called the reasonableness standard that is intended to be used to determine when the executive can remove an official within the executive branch. That removal must meet the standard of reasonableness. And this became a source of great controversy in the last few years when the Netanyahu government tried to basically knock down the reasonableness standard. The Supreme Court of Israel basically had to make a decision about whether it was going to risk undermining its authority altogether by upholding the reasonableness standard. But there is something parallel in the American case. That is to say, the criterion of for cause.
That's correct, and I think I'm glad you brought in the comparative perspective, because I think most countries have provisions like this or have limitations like this, so that whoever is controlling executive power can't just in an arbitrary, capricious, or willful way, for purely political reasons or other reasons, simply remove the government officials that are responsible for carrying out the law. And we're familiar with this idea in employment contexts outside of the government. So you might ask someone, a friend, a colleague, is someone at will employee, or do they have for cause protections? Right. That's essentially what we're asking in this context: is how does that framework apply to government officials?
Right. Well, I want to get back to the removal and the caprice that might be involved in it, but in more contemporary terms. But I'm just wondering about how expansive the vision of the unitary executive was in the tenure of Franklin Delano Roosevelt, sort of one of the most powerful presidents in American history. Were there versions of the theory of the unitary executive in FDR's time?
There were. And in fact, Franklin Roosevelt was on the losing side of an important case that was decided during his presidency called Humphrey's Executor. And this is one of the cases that right now is being essentially teed up for constitutional challenge by the Trump administration. So the Trump administration has explicitly called for the overruling of Humphrey's Executor, if need be, as a way of justifying the president's removal of independent agency commissioners who otherwise would have good cause protection. So what happened in the Roosevelt administration is that FDR tried to remove the commissioner of the FTC, a man named Humphreys, and this is what led to the constitutional challenge. And he lost. He lost resoundingly. It's very interesting that by a unanimous vote, the Supreme Court, about 9 years after they had decided the Myers case, to which we were referring a moment ago, sort of pulled back from the Myers holding and circumscribed it in certain ways, and laid the foundation for what today we understand as the independence of some government agencies. And the independence principally relies in the fact that the president can't remove those officials at will. He can only do so for good reasons, for cause, or in compliance with the particular language of the various statutes. Usually refer to things like inefficiency, neglect, maladministration, and so forth. But essentially it means for reasons, for good reasons. So FDR, although I don't think he's typically thought of as a proponent of the unitary executive theory in the way we would think of that today, because it's really that term and the way it's kind of developed is a more modern phenomenon involving people like Nixon, Reagan, and subsequent presidents. He was purportedly very angry about that decision. He thought he ought to have the power to remove this FTC official who was going to obstruct the implementation of his New Deal policies. And he was very bitter about the decision that what he thought of as a power properly belonging to the president would be denied him in that case.
So tell us now about the modern discourse about the unitary executive, that which certainly gains traction from the Reagan presidency on, maybe extending back, as you just alluded to, Nixon. What is different about the discourse in the last 70, 60 years or so?
Right. So I think that Watergate is a good place to begin to think about modern developments. So coming out of Watergate and the demise of the Nixon presidency, you can think of that as a period, the 1970s, in fact, when congressional power was at a high point and presidential power was at a lower point in relation to one another. I mean, the fact that the Nixon administration fell in the way it did, Congress was passing statutes that were meant to introduce a sort of a good government ethic, if you will, into the running of the government, including things like the ability to have independent counsel or independent prosecutors look into presidential or other high-ranking government conduct. And at the same time, mostly within the Republican Party, there was a cadre of people, and they came into power with the Reagan administration, who were critical of these developments and who felt the presidency had been unduly weakened and rallied around this idea of the unitary executive. So the Reagan administration came into power with a simple but powerful vision of the presidency. People like Ed Meese and other government lawyers were instrumental in sort of articulating this vision and carrying it into execution. And the vision was that all executive power in the government is vested by the Constitution and the president, that any other official in the government, therefore, who's not exercising legislative or judicial power is exercising executive power and controllable by the president. And so that means that all of those government officials, whether they're in agencies, whether they're in independent agencies, whether they're in the Justice Department, prosecutors, so on and so forth, all of those folks, at some level, by virtue of the way the Constitution is designed, must be controllable by the president, either through that removal power, but also generally through the use of other mechanisms of presidential control, executive orders, and so forth. That was the vision. And I think what made the 1980s different, and then the period thereafter, is on the one hand, you had strong personalities, people like Antonin Scalia, who was nominated and appointed to the Supreme Court, who very much held to this view. People like Ed Meese, who as Attorney General was prepared to tell all of the lawyers working under his supervision, we want to implement this in litigation, in policy, and so forth. And then maybe this is more of a feature of the 1990s. You had a younger, newer generation of law professors and scholars who had served in the Reagan administration, but who now were taking positions as law professors in the academy, who started writing about this and sort of theorizing, if you will, the unitary executive. So big, long articles on the president's power over foreign affairs, or the unitary executive, or the president's power over removal, or why Justice Scalia, who was the lone dissenter in a very important case called Morrison against Olson, which raised a lot of these questions, was right, and the majority was wrong. So both, I would say, inside of government, and then, soon thereafter inside the legal academy, you get a real kind of coordination and crystallization of a view about the unitary executive that's been with us ever since.
It's almost shocking to think that it was only 6 years from the resignation of Richard Nixon to the election of Ronald Reagan. That 6-year period must have been a period in which there were all sorts of cautionary notes about executive power, and then that was, in some sense, thrown out the window. One might expect a longer period of reservations about an imperial presidency, but it didn't last very long. And then you have this new robust discourse about the virtues of an expansive unitary executive. Striking.
That's right. And I think a common perception, perhaps, was that Gerald Ford and Jimmy Carter were weak, ineffective presidents, and couldn't get things done in the way that the president ought to be able to. And Reagan, of course, comes in as a big personality with a big agenda. Some of it has to do with federalism and returning powers to the states. Some of it has to do with shrinking the size and imprint of government, of the federal government. I mean, we see that, of course, today happening now in a much more amplified way. And the unitary executive was part of this. I wouldn't say it's the only thing going on by any stretch, but it is I guess another point to make is it became a kind of a legal argument as much as a policy argument. It became an argument to be vindicated in the courts and through the development of legal and constitutional doctrine. And that has not changed since that time. So essentially, the way the theory has unfolded, it has policy dimensions, of course, but we also have a lot of case law now that has, spoken to the issue and really furthered the theory in very major ways.
And is it fair to say that the expansive version of the unitary executive theory is a Republican stance?
I would say yes and no. I wouldn't go that far to say it's exclusively a Republican stance. So one can certainly point to actions by, the Clinton administration, the Obama administration, the Biden administration, which were justified by lawyers within those administrations. So the Office of Legal Counsel, for example, but also in public defenses that were really partaking of the unitary executive theory. So it might be the way the Clinton administration conducted the war in Yugoslavia, or the former Yugoslavia, right? The Balkan War, allegedly exceeding, the scope of presidential power, but in the name of a strong foreign policy power that's given to the president, or the Obama administration on immigration policy. So the decision of President Obama to refrain from enforcing some of the immigration laws might be seen as, related to this theory in the sense that he was saying, I have a lot of discretion given to me by the Constitution and by the statutes, and I'm going to exercise that discretion, but in a pretty dramatic way, right? That was criticized at the time. The Biden action, some of the measures during the COVID crisis, the student loan forgiveness and so forth. So I wouldn't go that far to say it's been exclusively a Republican agenda item, but I do think, certainly in the courts, it has tended to be that the Republican appointees to the Supreme Court are the great champions of the unitary executive theory, and the Democratic appointees or the liberal justices, including people like maybe Justices Souter and Stevens, who were appointed by Republican presidents, but who gravitated over time to a more liberal or moderate perspective, tended to be more critical. And the great champions have been people like Justice Scalia, Chief Justice Roberts, has authored many of the opinions that have really laid the foundation now, but also Alito, Thomas, the more recent appointees. There's a general sense that all of that group shares premises that go back to that Reagan White House, and the sense that I said that all of the executive power of the government is given to the president, and therefore there are strong limits on how Congress can restrict the exercise of that power. I mean, that's really what it comes down to. It's a question about whether Congress can limit the president in his exercise of executive power, including his control over other government officials who are allegedly exercising executive power.
Okay, so tell us now what is new about Donald Trump's view of the unitary executive.
Well, Donald Trump is aggressively, and the people around him, the people in his White House, they are aggressively deploying this unitary executive theory beyond where it's gone before. I think it's safe to say. So, beginning with the removal power. So, for example,
Inspectors General, was that a
yes, inspectors general, right? So the statutes say if you want to remove inspectors general, here's how you have to do it. You have to give 30 days notice and you have to go through these steps. But if the argument is those limitations that have been placed by Congress on the president's decision are themselves unconstitutional, then we don't have to comply with it. The firing of agency heads at NLRB or the FTC, or maybe we'll see now, Jerome Powell at the Fed. I mean, Donald Trump is making noises about this now, but in each case, what has until now been thought to protect officials like those from the at-will termination by the president is this case Humphrey's executor going back to 1935. And the Trump administration has made abundantly clear that it thinks that Humphreys either should be overruled or should be interpreted so narrowly as to not stand in the way of firing these officials. And what that would mean is essentially the end of independent agencies. I mean, that's a dramatic step that no previous president has been willing to take. It would mean that the way we've understood the org chart of the federal government for a very long time has to be, remodeled. It's not the organizational chart that we thought, where some agencies are independent of political control, but actually under presidential control. So that's new and very aggressive. And it remains to be seen how the courts will adjudicate those questions. I think a lot of people believe that they will hand Donald Trump a victory when it comes to this particular question, whether he can in fact fire the agency heads at NLRB or FTC or other agencies. And it's because the justices or a majority of justices have never been particularly fond of Humphrey's executor. They don't think perhaps it was rightly decided. They think it's not in line with the best understanding of the Constitution. So it's not unlikely, although it's not a foregone conclusion, that Trump may prevail in these cases. It is an open question, though. I mean, there's a counter argument, and because the court would have to essentially walk back a certain equilibrium that it had signaled was the stable state of affairs, where there are two big exceptions, as it were, that they had carved out from the general principle of Myers, or the principle of the unitary executive power over removal, and they would have to discard those exceptions and basically redo the law.
And can you sketch out what a post-Humphreys world might look like in terms of the operation of government?
Yeah, well, it's interesting because we're experiencing such a convulsive, unsettling period of time right now where government, as we have understood it to operate, is being dismantled and reorganized and so on before our very eyes. And that could become the way things work from now on. So what's good for the goose is good for the gander. I mean, it raises the question, for example, what would the next president do? What would a Democratic president do? And are we going to, rather than have a fairly stable government in the area of the administration of the law through administrative agencies, we're going to have a much more convulsive and politicized administration of the law that might change based on one election or the other. You might say that this raises the stakes of presidential elections even higher. They were already enormously high. I mean, I think we're all familiar with that. But it would raise those stakes even higher. And it would mean that, I guess, just to flesh this idea out a bit, the very idea of a body of impartial or relatively impartial and highly informed experts who help administer the laws in areas of environmental policy or monetary policy or food and drug regulation or all kinds of things that we have taken for granted until now should be and are to a large extent being administered impartially or relatively impartially by people who know a lot and are really out for promoting the general welfare, not for promoting a particular political agenda. That just might change. And that would be, I think, a loss from my perspective, but it could be where we're headed.
One of the effects of this expansive view of the unitary executive, it seems to me as a non-legal observer, is that it necessarily, or at least in this case, encroaches upon the other branches of government. It necessarily entails a somewhat dismissive view of the judiciary, and it necessarily entails, it would seem, an attempt to borrow or co-opt from Congress some of the powers that have typically been its own. It almost seems as if it's a necessarily zero-sum game. You expand the executive. The effects are not confined just to the executive branch. It entails the diminution of the powers of the other branches, which is really a radical reordering of the American system of government.
I think that's exactly correct. And it's a point that's easily lost, in the shuffle, that often these assertions of presidential power come at the expense of other departments of government, other branches of government. If you think of Congress, for example, that's also amplifying a democratic deficit, if you will, in our government. I mean, the way the government is supposed to work is that lawmaking is conducted by the people's representatives in Congress, and the people have an opportunity to shape the development of law and policy in just that way. But if the modern reality is that most of the regulation or even lawmaking is happening in the agencies, and one person ultimately controls how that is unfolding, well, if you think that we don't have such a great set of processes when it comes to electing the president, given the money in politics and just the way presidential elections have unfolded, you might think that that's another cost as well. But just going back to your point, it's certainly the case that a lot of this aggrandizement of presidential power comes at the expense of Congress and at the expense of the courts. I mean, we're going to see now to what extent the courts are willing to hold the line and assert a proper scope of judicial power in the face of presidential assertions of authority that would seem to impinge upon that. But that's a hard thing for courts to do. I mean, the refrain is often heard, we shouldn't expect the courts to save us. And for various reasons, that go into the complexity of how adjudication works and the limits on the judicial enforcement of judicial judgments and so forth. It is a hard thing for the courts to do, but they do have tools at their disposal, and we're going to see how this unfolds.
Well, this has been a really fascinating conversation. I'd like to thank you, John Mikhail, Carroll Professor of Jurisprudence at the Georgetown University Law Center, for making time out of your busy schedule to be with us today.
Thanks, David. It's been a pleasure speaking with you.
Thank you for listening to Then and Now, a podcast by the UCLA Luskin Center for History and Policy. You can learn more about our work or share your thoughts with us at our website, luskincenter.history.ucla.edu. Our show is produced by David Myers and Rosalind Campbell, with original music by Daniel Reichman. Special thanks to the UCLA History Department for its support, and thanks to you for listening.